Thinking about divorce in St. Charles? The process here is more specific to our area than you might realize. Missouri is no fault, but a spouse's misconduct can still cost them dearly. The court will pay attention. In another term, equitable distribution doesn't mean what most people assume it does for your assets. It means fair, not a 50-50 split. The court can and will divide property unequally based on certain factors. We will break down the specific rules, financial traps, and custody realities you must understand for a St. Charles divorce. So beyond these major misconceptions, what are the basic ground rules you are required to follow? First, a mandatory 30-day waiting period starts after filing. Nothing can be finalized before that point. Next, your case is either uncontested, meaning you agree on all terms, or contested if there is any disagreement. And for parents with minor children, Missouri requires you to complete a parent education class and file a parenting plan. Beyond assets, let's discuss something often overlooked: debt. In Missouri, debt acquired during marriage is marital debt. That credit card or car loan will also be divided equitably, not just down the middle. The court looks at who can pay. But why is equitable not 50-50? In a moment, you will see exactly what specific factors St. Charles judges weigh. It's about the full picture: each spouse's financial condition, their contributions, and their conduct during the marriage. The same logic applies to spousal support. There is no automatic formula. A judge has discretion based on need and ability to pay. So the reason it's not a 50-50 split is because the court's goal is a fair result, using these personal factors to define it. With so much discretion at play, what is the single, non-negotiable financial rule you have to follow? Full financial disclosure. Hiding assets can bring severe penalties, like losing that asset or having the divorce reopened later. Let's see how these principles apply in more difficult, real-world St. Charles divorce cases. Consider a high net worth divorce with a family business. Valuing that business for division is not simple at all. It requires forensic accountants, and decisions have massive tax implications. Proving financial misconduct is a high-stakes affair. Or take a military divorce, common near Scott Air Force Base. Here, state law meets federal rules for pensions and deployments. Given these difficulties, is battling it out in a courtroom your only option? Often, no. Mediation offers a private, cost-effective path. But what happens when the children are the central issue? In St. Charles, all custody decisions are based on the best interests of the child, not the parents' wishes. A mature child's preference is considered, but it's never the only factor. A judge has the final say until the child is 18, and the old assumption of mothers getting custody is gone. Courts now evaluate parents on equal footing, focusing on involvement. So when children are involved, the process is a detailed evaluation of parenting focused solely on their best interests. Knowing all this, how do you avoid the biggest mistakes that can derail your case and your future? Recall our opening? That conduct matters. Letting emotion drive spending can be used against you as financial misconduct. And recall all those discretionary factors for assets, support, and custody. The biggest mistake is hiring someone who doesn't know local judges. The legal principles are statewide, but their application is local. Success here means knowing the local legal culture. From property division to child custody, divorce in St. Charles is not a generic process. It's a distinct arena. You are not just dealing with a legal system, you are dealing with the St. Charles County legal system. Knowing that is key. An informed decision is a powerful decision. Don't leave the most important outcomes of your life to misconception. If you are facing this process, your first step should be to speak with a legal professional who specializes in St. Charles County.